second time.
Mr. Assistant President. Mr. Assistant President, I lead for the opposition on the Housing Legislation Amendment Bill 2016, and I can say at the outset that the opposition does not oppose the legislation, although we do have one amendment which has been placed by the Clerks to provide for a little bit more rigour and transparency in the process. Mr. Assistant President, the Honourable Minister was, his contribution on the last occasion was replete with the usual self-congratulations that this government has become a hallmark of this government, most undeservedly, appropriating for themselves credit for what is really in part an implementation of a national scheme. But, Mr. Assistant President, the bill seeks to amend the Housing Act 2001 to enable the Land and Housing Corporation, which is the owner of social housing assets in this state, to enter into what are called concurrent leases with registered community housing providers. And the second feature of the bill is to amend the Community Housing Providers Adoption of National Law Act 2012 to allow the establishment of local registration schemes for community housing providers unable to register under the existing national scheme. And I'll come back to that second point in short order, because it's concerning the second aspect that our amendment is directed to. Mr. Assistant President, the Housing Act 2001 was introduced by the Carr Labor government and provides the legislative framework for social housing in this state. The Land and Housing Corporation was established under the Act as the body to own and manage the New South Wales Government's social housing portfolio, including all land, buildings and other assets, and currently comprises about 130,000 properties valued conservatively at about $35 billion. The Community Housing Providers Adoption of National Law Act 2012 was adopted to create uniform state provisions consistent with Commonwealth legislation regarding the registration, monitoring and regulation of community housing providers, which, as all people in this chamber would understand, are crucial to the housing landscape and fabric not only in New South Wales but across the nation. At present, there are approximately 37,000 community housing tenancies in New South Wales. At present, certain entities, such as Aboriginal land councils and local government authorities, are unable to register as part of the national scheme because they're unable to insert wind-up clauses into their governing documents. And and I note that the Minister in his second reading speech particularly referred to the wind-up provisions governed by the Aboriginal Land Rights Act 1983, and the ability to register as a housing provider was important because it enables local organisations that deliver housing services, such as local Aboriginal land councils, to be provided assistance as housing providers where they do meet their criteria for registration. Schedule 1 of the bill will amend the Housing Act 2001 to enable the Land and Housing Corporation to enter into concurrent leases with registered community housing providers. A concurrent lease is a transfer of the rights and obligation of a landlord under a lease to a different new party. These amendments will enable the Land and Housing Corporation to transfer its obligations as a landlord to a community housing provider. This would result in a tenant paying rent to the community housing provider rather than to the New South Wales Government. A community housing provider would also be responsible for property maintenance. Land and Housing Corporation will be enabled by this legislation to transfer a tenant's file and a tenancy to a community housing provider without the requirement of the consent of the tenant. A tenant's personal and health information can only be transferred by Land and Housing Corporation if it's satisfied that the community housing provider has procedures in place to ensure privacy. So there are checks and balances. Schedule 2 of the bill will amend the Community Housing Providers Adoption of National Law Act 2012 to require the Minister for Family and Community Services or the Minister for Social Housing, and I note, of course, that this government doesn't have a portfolio of designated housing, to establish a local registration scheme. The legislative amendment we propose would enable, the amendment in the bill would enable entities previously unable to register as a community housing provider under the national scheme to do so under the local scheme. And the bill is said to be intended for the local scheme to follow the national scheme with consistent measures related to registration, monitoring and regulation of community housing providers under the national scheme. But we've noticed, and we've had obviously feedback from the broader community, that the Minister, of course, is not required under the legislation or the bill to provide any reasons why an entity would be registered under the local scheme rather than the national scheme. leaving aside the examples where, for legislative reasons, they're simply not able to be registered. But we think an onus should be placed on the Minister to ensure that only organisations unable to be registered under the national scheme due to structural and legislative reasons are registered under the local scheme. And I refer again to the example given by the Minister of Aboriginal Land Councils and local government authorities rather than other non-compliant entities. And we think, therefore, the amendment we propose, which simply requires that in establishing a local registration scheme, the Minister must, when determining whether or not to register an entity under the scheme, have regard to the reasons why the entity was unable to be registered under the national law, and to publish those reasons in the Gazette. And this is important because if there is a reason why an entity should be a community housing provider in this state, but it's prevented by provisions of other legislation, but otherwise it could fulfil a good and useful function in the social housing space, then yes, they should be registered under this legislation and be permitted to bring forward those activities. But we do think there needs to be a safeguard, a further check and a balance, and a little bit of transparency that requires the Minister to have regard to why an entity is not able to be registered under the national scheme. And that just simply is a prompt to whoever the Minister from time to time is, just to have a look at the reasons, because there may be reasons which don't relate to structural or legislative impediments, and we wouldn't want any entity registered in the state to interact with, often vulnerable families and individuals in the social housing space where there, for example, could be potentially any question mark over their track record. I'm not saying that governments would rush into registering such entities, but if there is any such controversy in an organisation's history, the amendment we propose, which by the way wouldn't stop the Minister from ultimately registering them, it's just a prompt, a little requirement that the Minister pauses and has a think about why that entity was not able to be registered under the national scheme. And we think that is necessary because the people to whom services are being provided are often vulnerable and have hardships, and we think this modest proposal is just a precautionary additional safeguard for them. As I said, this is not to impugn the motives of the Minister or the government, but simply to say that all caution should be taken. Because we accept the example given by the Minister, but the legislation would go further and would permit entities to be registered in New South Wales who weren't able to register under the national law, who were not able to be registered for other reasons. And we just think, and we'd invite the government to accept that we're also engaging constructively and in good faith with this legislative proposal just to provide this small additional safeguard.